All right, welcome to Module 14. This is week 7. Our subject is the judicial branch, which is the third constitutional branch of the federal government, and has, vaunted itself into the middle of several important controversies concerning, again, the nature of Americans' rights regarding access to guns, and of course, women's access to reproductive health. Federal law initially dealt with a relatively narrow set of issues related to immigration, interstate commerce, copyright, things like that. To illustrate why some laws have been elevated to the status of federal crime. For example, in the 1930s, there were an escalating number of bank robberies where the bank robbers were using cars and machine guns to cross state lines and evade capture, and they were oftentimes outgunning local police. That interstate dimension, combined with the fact that robbers were using cars and high-powered submachine guns, eventually led the Federal Bureau of Investigation to become the lead agency dealing with those kind of crimes. If you haven't noticed, if you're in a bank, they are very quick to point out that bank robbery is a federal crime. So over time, federal law has expanded to include things like civil rights protections as well. Under the previous government, by which I mean the Articles of Confederation, no provision had been made to establish a separate and independent judiciary. The Constitution's framers insisted on the establishment of a separate and independent judiciary, which was another point of contention between the Federalists and the Anti-Federalists. The latter group feared that a federal judiciary would infringe upon the state judiciary's rights. So what are the basic functions of the judicial branch? The assigned reading notes there are 5 basic roles the judiciary plays in the governing process. First, the judiciary plays an important role within the system of checks and balances. The framers didn't want the judiciary to be entirely dependent on either the executive or the Congress. Second, the judiciary is responsible for adjudicating and interpreting the law. In this case, in this sense, the federal courts are venues for resolving disputes. American courts are generally passive. That means they have to wait for cases to be brought before it, as opposed to Congress and the president, who can take action within their own respective sphere of authority. Third, because of the supremacy clause in Article 6 of the Constitution, federal law is considered to be the higher law, and so instances where federal and state law conflict, the federal law prevails, and generally speaking, those kinds of conflicts are adjudicated in federal courts. Fourth, the judiciary provides an unbiased check on the passions of the people, and that's, in that sense, the judicial branch is what we call a republican institution. So part of the reason why judges serve for life under good behavior is to ensure that federal judges are at least somewhat insulated from the popular will and can act in ways that restrain the public from taking imprudent actions. The downside is that such, insulation can be empowering, and justices can take decidedly unpopular actions that directly clash with the public will, which is what I think has been happening recently with the Supreme Court's June decisions on both guns and abortion. Fifth, an independent judiciary, as argued by Alexander Hamilton in Federalist 78, would have the power of judicial review, which refers to the power of the court to strike down laws or executive actions or state actions that, in the judgment of a majority of the 9-member court, views as a violation of the Constitution. The judiciary is established by Article 3 of the Constitution, which is the shortest and most vague of the 3 articles establishing the principal institutions of the federal government. Article 3 sets the terms of office. It establishes rules covering compensation and the jurisdiction of federal courts. The term of office for federal judges is life under good behavior, meaning that effectively that federal judges are removed from democratic accountability. Federal judges can retire, they can resign, and if allegations of wrongdoing emerge, they can be removed via the same constitutional expedient as presidents, vice presidents, and other executive branch officials by way of impeachment, which again requires a majority vote in the House of Representatives on some, one or multiple articles of impeachment, and then a 2/3 majority of the Senate must then vote to remove that person, which today that requires 60 votes, and that is a high bar for removal. The criterion for impeaching judicial officials is the same: treason, bribery, or other high crimes and misdemeanors. No Supreme Court justice to date has been removed, but 15 federal judges have been impeached by the House, and 8 of those 15 have been successfully removed by the Senate. Most often, judges have been impeached for bribery or allegations of bribery, or for conflicts of interest suggesting bribery. It's always important to keep in mind that impeachment is a political remedy for what are deemed political abuses. An abuse of office is a political kind of crime. You can be prosecuted for it after the fact, but in the meanwhile, impeachment again is viewed as the office is being cleansed of a tainted person. Article 3, Section 1 of the Constitution also addresses the issue of compensation, stipulating that judicial salaries cannot be cut as a way of punishment. That was a common way of getting rid of judges viewed by a state's political elites as hostile to their interests during colonial times. The jurisdiction of federal judges is confined to actual disputes, not imaginary ones. Neither the Congress nor the President can come to the judiciary and say, we would like some advice on this. That's why you actually have the White House Office of Legal Counsel, which is there again to provide political advice. The judiciary established the principles of, again, political questions to avoid becoming ensnared in disputes between the executive and legislative branches of governments. The kinds of disputes that fall within the jurisdiction of the federal judiciary include cases affecting ambassadors or other public ministers and councils. Case number 2, cases of admiralty and maritime jurisdiction, any such controversies in which the United States is a party to the dispute. 3, controversies between 2 or more states. 4, controversies between a state and citizens of another state. 5, controversies between citizens of different states. 6, controversies between citizens of the same state claiming lands under grants of different states, and between a state or citizens of a state and foreign states, citizens or subjects. So these are the sorts of disputes that are all considered to be kind of part of the federal judiciary's original jurisdiction. Those kinds of cases are oftentimes heard directly by the Supreme Court. The congressional statute responsible for establishing the federal judiciary was the Judiciary Act of 1789. It was one of the first acts of Congress, and it achieved like 5 separate important things. 1, it described the powers and responsibilities of district, appellate, and Supreme Courts. It kind of created that pyramid section, that pyramid organization of the court. Number 2, it created the requirement that each state contain at least one federal district court, and those federal district courts, as I'll mention in a little bit, these are the cases of original jurisdiction. 3, it sets the number of justices of the Supreme Court at 6. At that time, again, 1789. By 1869, Congress had kind of fiddled with the numbers, and by 1869 had arrived at a number of 9, and it's been that way ever since. But that is something that Congress can change at any point. 4, it outlined the powers of U.S. Marshals and U.S. Attorneys. And then 5, it created a cabinet-level office for the Attorney General, which now today, of course, is known as the Department of Justice. Below the Supreme Court, the Constitution authorizes Congress to ordain and establish inferior courts, most of which fall into 2 categories. At the lowest tier of the federal judiciary are the district courts, which I just mentioned, where federal crimes are tried. So what makes a crime a federal matter as opposed to falling within the jurisdictions? I mentioned bank robberies a little while ago. Largely, whether an action is a federal crime is determined by Congress, and I mentioned that a little while ago with regard to bank robberies. I would also note that one way the FBI attacked organized crime was to make it a federal crime to transport underage girls across state lines. That was a major part of the mafia's business model: get young girls hooked on drugs and alcohol, and then move them from the East Coast to the West Coast and to points in between. Places like Los Angeles, Las Vegas, Chicago, Kansas City. These were major points of operation for crime bosses. There are 94 district courts in the 50 states, and each state, again, has at least one federal district court. In between the district courts at the base and the Supreme Court at the top, there are the circuit courts of appeal. These are also known as the U.S. Courts of Appeal, and they hear appeals coming from the district courts. There are 13 total circuit courts. 11 are organized to cover several states. And then there are two more courts, one for the District of Columbia and one for the Federal District, which is where a lot of the technical copyright-related issues are handled. There are 179 circuit court judges, and they are distributed somewhat unevenly across each of the circuits. The largest circuit in terms of the number of judges is the Ninth Circuit, which covers the West Coast, Arizona, Nevada, Idaho, and Montana. It's a huge district, kind of regionally. There are 29 circuit court judges that sit on the Ninth Circuit Court, while the First Circuit, which only covers Maine, New Hampshire, Massachusetts, and Rhode Island, only has 6 members. Typically, circuit courts hear appeals in 3-judge panels, and their job is to ensure that the laws and procedures germane to a case were followed, and that the loser of the case nevertheless enjoyed due process of law. Occasionally, on really important cases, a circuit court will sit en banc, which is French for in bench, meaning that all the judges are hearing the case and all the judges will vote on a case. And that changes the dynamic, because a lot of times you'll get 2 judges that might have been appointed by a conservative justice or a liberal justice, and then only one judge from the other kind of ideological spectrum. And so that can kind of change the nature of things. The Supreme Court is the highest court in the land and the only federal court expressly authorized in the Constitution. The Supreme Court is comprised of 8 associate justices and 1 chief justice. The building housing the Supreme Court is nicknamed the Marble Palace, and it sits across from the Capitol on First Street. The Supreme Court is responsible for ensuring that the laws are correctly interpreted and do not violate the Constitution. Historically, the Supreme Court has been one of the more popular of the political institutions of the federal government. Judges generally draw heavily upon precedent in interpreting the law, and the principle of stare decisis, which is Latin for let the decision stand, is viewed by judges as an important norm, not necessarily sacrosanct, but very important. Most of the judges on the Supreme Court, justices on the Supreme Court, will tell you they believe strongly in stare decisis. Clarence Thomas is one of the exceptions. He basically says, we rely on stare decisis when we don't want to think about an issue, which I think is frankly deeply problematical for Mr. Thomas. For Justice Thomas, I should use his correct honorific. The reliance on stare decisis is a key element of the judicial philosophy of judicial restraint, which basically argues that as unelected judges, they should show deference to the actions of the President, Congress, and the popularly elected state legislatures and things like that, unless those actions are clearly repugnant to some principle of the Constitution. The idea of judicial review suggests that federal judges have the authority to strike down portions of a statute or executive action that violates the Constitution or that violates people's civil liberties. Most scholars believe that judicial review is an asserted power established by the court itself. In the Supreme Court case Marbury versus Madison, which was decided in 1803, where Supreme Court Chief Justice John Marshall wrote, "It is emphatically the province and duty of the judicial department to say what the law is." Marshall argued that the vesting clause at the start of Article 3 included the inherent power of judicial review. The case Marbury versus Madison dealt with the Judiciary Act of 1789, but also with the outcome of the 1800 elections, which was the first American election in which the governing party, which at the time were called the Federalists, lost control of both Congress and the presidency. The Judiciary Act significantly expanded the authority of the federal judiciary by establishing 13 district courts and 3 circuit courts and delineating the jurisdiction again of each level of the federal judiciary. In the aftermath of the Federalists' defeat in the 1800 election, it's important to keep in mind back then there were oftentimes up to 6 months before the government would change hands. I think that the actual kind of swearing in of presidents and all these other officers sometimes happened as late as mid-March, whereas you'd have the elections in November. And so before the newly ascendant, what were known as the Democratic Republicans, assumed power, the administration of John Adams went and made numerous judicial appointments, including one for a man named William Marbury. Unfortunately for Mr. Marbury, his judicial commission got lost. He was confirmed, but the paperwork got lost. The incoming administration was angry. The incoming administration of Thomas Jefferson was furious at all these judges being appointed in what they viewed as a violation of the popular will. And Jefferson ordered all the undelivered appointments to be held up, leading Marbury and a number of other frustrated judges in waiting to file a lawsuit to force Jefferson's Secretary of State, who was James Madison, to deliver the commissions. Now, one judicial commission had been delivered, and that was the commission for John Marshall to assume the position of Chief Justice of the Supreme Court. He had just prior to that been the Secretary of State, occupying James Madison's position within the Adams administration. He had a dilemma. On the one hand, he believed that the Jefferson administration was legally obliged to deliver the commissions because those individuals had been confirmed. On the other hand, he knew he had no direct authority to compel the Jefferson administration to do something the president had sworn publicly that he would not do. So Marshall resolved the dilemma this way. First, he held that the Jefferson administration's decision to withhold the commissions were illegal. However, he held that he lacked the authority to issue what was known as a writ of mandamus, which again, a mandamus is Latin for we command, because he argued that the section of the Judiciary Act that granted the Supreme Court that authority was a violation of the separation of powers and was therefore unconstitutional. So in doing so, Marshall asserted for the court the power of judicial review, but did so in a way that forestalled a conflict between the court and the presidency that the court was unlikely to win. Many Americans assume that because the American federal judiciary has judicial review, that judicial review is a necessary feature of democratic governance. In fact, an independent judiciary with judicial review is a Republican feature of of our constitutional system, but it's not that common outside the United States. So if you think about, for example, the United Kingdom, their governmental practices, they practice something known as parliamentary sovereignty, which means that acts of parliament are by their essence constitutional, which again precludes an independent judiciary striking down its particular statutes. And in fact, they just created a Supreme Court in the United Kingdom, but they do not have judicial review. Okay, I think I've droned on long enough. If anyone has any questions regarding this presentation or anything I have not touched upon in this, that's in the assigned reading, please bring your questions to the weekly discussion and I'll try to get to them. Let's have a great week.